I'm the Director of the Office of Electric, Gas, and Water at the New York State Department of Public Service. I have been designated to serve as the alternate representing the chair of the New York State Board on Electric Generation Siting and the Environment, or as it is also known, the Siting Board. I call this meeting of the Siting Board to order. Before moving to the agenda, I would like to introduce the alternates representing the permanent members of the Siting Board. Louis Alexander, alternate representing the Commissioner of the Department of Environmental Conservation. Dr. Elizabeth Lewis Michael, alternate representing the Commissioner of the Department of Health. Vincent Ravashear, alternate representing the Commissioner of the New York State Department of Economic Development. And John Williams, alternate representing the Chair of the New York State Energy Research and Development Authority. I would also like to introduce the ad hoc member for case 19-F-0299, Norman Pavlak. Secretary Phillips, are there any changes to the agenda?
There are no changes to the agenda.
Thank you, Secretary Phillips. We will begin with case 19-F-0299, application of the Excelsior Energy Center, LLC, for a certificate of environmental compatibility and public need, pursuant to Article 10 of the Public Service Law, for construction of a solar electric generating facility in the town of Byron, Genesee County. Presented by Greg Sayer, Administrative Law Judge, Department of Public Service. Molly McBride, Administrative Law Judge, Department of Environmental Conservation. Dakin Leacakes, Chief Administrative Law Judge, Department of Public Service. Jason Zaire, Chief of Environmental Certification and Compliance, Office of Electric, Gas, and Water, Department of Public Service. Corey Strube, Utility Supervisor, Environmental, Office of Electric, Gas, and Water, Department of Public Service. And Robert Rosenthal, General Counsel, are available for questions. Judge Sayer, please begin.
Thank you very much, and good afternoon. Please feel free to interrupt me at any time with questions. After the public involvement program and preliminary scoping statement processes, the application in this case was filed on December 28, 2020. After it was updated, the chair of the Siting Board found that it was compliant with the filing requirements in the statute and regulations on April 8, 2021, which started the one-year clock for the Siting Board to make its decision. The project is a proposed solar farm with up to 280 megawatts in capacity in the town of Byron in Genesee County. The total project area is 3,443 acres, but the limit of disturbance for construction and operation is less, 1,712 acres, of which 1,629 acres are inside the proposed project fences. The collection lines are proposed to be underground, and there is a proposed substation and switching yard to connect the project to a New York Power Authority 345 kilovolt transmission line, which runs very close to the project. There is also a proposed battery storage facility with a 20 megawatt 4-hour duration capacity. There were 5 active parties in the case: the applicant, DPS staff, DEC staff, Department of Agriculture and Markets, and a local intervener group called Byron Association Against Solar, Inc., which I'll refer to as BAAS. The town of Byron requested and received intervener funding at both the pre-application and post-application stages, but it did not file testimony or briefs. Settlement negotiations in this case took place between April and August of 2021, and a proposed settlement among 3 of the 5 active parties was filed on August 25th. The settling parties reached full agreement among themselves. They are the applicant, DPS staff, and DEC staff. The Department of Agriculture and Markets and BAAS opposed the settlement. Testimony was filed by all 5 parties, and the evidentiary hearing took place on October 6th. There was a round of briefs and reply briefs, and the case is now before you for decision. The Department of Agriculture and Markets and BAAS contested only a limited number of issues, which means that many of the findings that the statute requires are uncontested. These uncontested issues and findings include the finding that the facility is a beneficial addition to the state's electric generation capacity, consistent with state energy policy, beneficial to fuel diversity and zonal energy pricing, non-impacting to environmental justice areas, and most of the environmental issues have also been settled and uncontested, including threatened, endangered, and invasive species, ground and surface water, wetlands, air quality, public health, safety, and security, noise, decommissioning and restoration, cultural, historic, and recreational resources, infrastructure impacts, and state and local laws and regulations, with one exception to the local laws issue, which I'll discuss later. The draft order addresses all the uncontested issues in detail, with full citations to the record, and makes the required findings, such as adverse environmental impacts, being minimized or avoided to the maximum extent practicable. I won't discuss the uncontested issues further unless you have questions. The contested issues fall into three areas: the use of agricultural land, particularly prime farmland, the impact of the project on the character of the community as a result of its size and visual impact, and the alleged non-compliance of the project, not with local laws, but with the Town of Byron and Genesee County comprehensive plans. I'll start with the farmland issue. The Department of Agriculture and Markets objected to 30% of the project being located on prime farmland, and objected that a solar energy project constitutes a permanent conversion of farmland to non-agricultural uses. The draft order finds that the argument about permanent conversion of farmland has been considered before by the Siting Board and was rejected in the Hecate Energy Albany case, decided in January of 2021. In that case, the Siting Board concluded that a commercial solar facility does not result in a permanent loss of farmland, where, as in both that case and in this case, the certificate conditions require the land to be fully restored as closely as possible to its prior condition upon decommissioning, with appropriate security for the decommissioning. In this case, there is some permanent loss of farmland due to access roads and other similar construction, but it amounts to only about 31 acres, which is less than 1% of the project's area. The draft order also notes that the applicant has agreed to follow the Department of Agriculture and Markets guidelines for solar energy projects, which deal with construction mitigation for agricultural lands. The developer also has agreed to hire a health, safety, and environmental manager with agricultural qualifications, as well as agreeing to various reporting requirements and coordinating requirements that involve, in the future, in the compliance phase of the case, Department of Agriculture and Markets staff. Although the department is certainly correct that agricultural production will be reduced in the footprint of the project for approximately 30 years, the reason behind that loss is that the property owners in question have voluntarily entered into lease agreements with the applicant. BAAS offered two studies to support its position that the project will have a massive negative impact on farming in the town of Byron. One of the reports was based on a completely erroneous number of affected acres, starting from the proposition that 3,500 acres of agricultural land would be removed from use for the life of the project. The correct acreage is 1,712, about half the amount in the study. That report is also deficient in using 1 year of crop pricing in its analysis of impacts, rather than a longer average, given the price fluctuation that actually occurred over the course of several years in the town's top 10 crops. The second study, produced by BAAS, claims that the project would cause a redistribution of farms and lands and an increase in farming costs, but it fails to support with underlying evidence its conclusions that the project would increase the cost of farming in the area. BAAS also put in the testimony of a large dairy farmer who stated that he would lose the use of farmland on which he spreads excess manure. It is certainly credible that the loss of this manure spreading arrangement could impact the dairy farmer's operations. However, the dairy farmer has been aware of this project for a number of years and only has an informal oral agreement with the landowner in question. That landowner decided he wanted to lease the land to the developer, and there's nothing legally preventing him from doing so. The order finds no basis on which the manure spreading usage by the dairy farmer should prohibit the landowner in question from making his own decision about leasing his property. Under all these circumstances, the order concludes that the negative agricultural impacts have been avoided or minimized to the maximum extent practicable. The second issue in dispute is the impact of the project on the community's character. BAAS offered the testimony of witnesses who stated that the visual impact of the project would destroy the small town feeling and tight-knit community spirit of the area of the project. However, that testimony does not directly take issue with the significant visual screening measures that the applicant has agreed to take. A fair number of plantings, the use of existing woodlands and hedgerows, and other screening measures. The testimony also does not take direct issue with the visual impact analysis offered by the applicant that indicates that there is minimal expected visibility within the affected visual study area, which is the area within a radius of 5 miles around the fence line of the project. Under these circumstances, the draft order concludes that the BAAS testimony is overstated in claiming that the project will destroy the rural community and finds that visual impacts have been avoided or minimized to the maximum extent practicable. The third issue in dispute is based on the testimony of a local resident who is speaking for himself, not for the town or the county, that the project is inconsistent with the town and county comprehensive plans. The resident is absolutely correct in stating that the protection of agricultural lands is listed as a goal in both of those plans. But the draft order finds that the argument of the project's inconsistency with these plans fails for 3 reasons. First, the town comprehensive plan also explicitly supports the development of clean energy resources. So there is necessarily, as with most land use issues, some balancing required of competing goals. Second, the town in 2021 adopted a solar law that allows for some agricultural siting. The town found that the law was consistent with its comprehensive plan, and the county planning board implicitly found that the law was consistent with both the town and county comprehensive plans when it approved the town law. It is also noteworthy that the project disturbs less than 1% of the county's prime farmland. Third, as I noted, the BAA witness was speaking for himself. Neither the town nor the county chose to file testimony or briefs against the project. The draft order concludes that the project is, in fact, not inconsistent with the town or county comprehensive plan. I should note that the applicant requested a waiver of 10 specific requirements of that town of Byron local law. The applicant produced evidence that with respect to these requirements, compliance would make it uneconomical to build the project. No party opposed those proposed waivers, and the order grants them. Finally, as a housekeeping issue, the draft order deletes a provision in the proposed certificate conditions that would have allowed compliance filings and informational reports prior to the board's approval of the project. It's really a moot issue because the board is acting on the project today and there were no such filings. But that kind of provision was rejected in a prior siting board case, and it is proposed to be rejected here to give notice to future parties. That wraps up my presentation, and we're available for questions.
Thank you very much, Judge Sayer, for your comprehensive summary of the item before us. I believe that the proposed draft order granting a certificate of environmental compatibility and public need for the Excelsior solar generating facility is well balanced and avoids or mitigates impacts to the extent practicable. I will be supporting the item. Let me turn to my fellow board members for any comments or questions. Mr. Alexander.
Thank you. I had certain questions relative to the agricultural resources analysis. And in this proceeding, as noted, the Department of Agriculture and Markets has raised certain salient points regarding the use of prime farmland for the siting of solar projects and the potential implications thereof. However, the presentation today, as well as the discussion in the order, has fully addressed the the questions that I was going to pose. So I would thank you, Mr. Sayre, Judge Sayre, for the review of that issue. With that, I have no further questions or comments.
Thank you, Mr. Alexander. Dr. Lewis Michael?
No questions or comments.
Mr. Ravishir?
I have no questions or comments.
Mr. Williams?
No questions or comments.
Mr. Pavlak?
Nothing.
Thank you. I will now call for a vote. My own vote is in favor of the recommendations as described. Mr. Alexander, how do you vote?
I vote in favor.
Dr. Lewis Michael?
In favor.
Mr. Ravishir?
In favor.
Mr. Williams?
In favor.
Mr. Pavlak?
Not in favor.
Thank you. The order is approved and the recommendations are adopted. Next is case 18-F-0262, application of Highbridge Wind LLC for a certificate of environmental compatibility and public need pursuant to Article 10 to construct an approximately 100 megawatt wind-powered electric generating facility located in the town of Guilford, Shenango County. Presented by Norina Chowdhury, Assistant Counsel, Department of Public Service. Jason Zare, Chief of Environmental Certification and Compliance, Office of Electric, Gas, and Water, Department of Public Service. Corey Strube, Utility Supervisor, Environmental, Office of Electric, Gas, and Water. And Robert Rosenthal, General Counsel, are available for questions. Ms. Chowdhury, please begin.
Good afternoon, Chair Designee Mitchell and members of the Board. Before you today is an order granting a petition for amendment of the Board's March 11, 2021 order granting a certificate of environmental compatibility and public need with conditions to Highbridge Wind LLC. The certificate authorized Highbridge to construct and operate a utility-scale wind power project in the town of Guilford, Shenango County, including the installation and operation of up to 25 wind turbines, together with associated collection lines, access roads, permanent meteorological towers, an operations and maintenance building, and a battery storage system. On December 9, 2022, Highbridge filed a petition for amendment seeking approval to increase the facility's nameplate capacity from 100.8 megawatts to 103.5 megawatts, modify Certificate Condition 43C related to Federal Aviation Administration approval of lighting systems by removing the phrase prior to commencement of construction, and modify certain facility component locations including the collector substation and point of interconnection substation, wind turbines, and supporting infrastructure. The Secretary to the Siting Board consulted with the staff of the Department of Public Service, the Department of Environmental Conservation, and the Department of Health before issuing a March 22, 2022 letter concluding that the proposed modifications would not result in a significant adverse increase to environmental impacts as compared to the certificated project. Therefore, the modifications did not constitute a revision that would require a hearing under the regulations. Highbridge explains that the increase in nameplate capacity is needed to optimize facility production and accommodate the chosen turbine technology for the facility. With respect to Certificate Condition 43C, Highbridge explains that the language as it currently reads could prohibit the commencement of tree clearing and site preparation activities, and specifically requests removing the phrase prior to commencement of construction from that subpart. Removing the phrase clarifies that the FAA approval of turbine lighting systems is required with the FAA determinations for the final turbine locations. The draft order before you explains that the requested change is procedural in nature. However, DPS staff raised a concern regarding the certificate holder's reliance on Siting Board precedent to assert that its certificate requires final FAA determinations prior to turbine erection. As noted in the draft order, that interpretation is appropriate if Highbridge posts letters of credit prior to the start of civil construction. Highbridge explains that the various layout changes, which includes shifts of 9 turbine locations, are needed to optimize facility design, address concerns raised by parties, and ensure compliance with the requirements of the certificate. The Secretary's letter included a thorough review and addressed potential impacts of the proposed changes for the project related to land use, noise and vibration and shadow flicker, cultural resources, geology, seismology and soils, terrestrial ecology, wetlands and streams, visual impacts, effect on communication, and local laws. As summarized in the draft order before you, The proposed changes will not result in a significant adverse increase to environmental impacts as compared to the certificated project. Accordingly, the draft order before you approves the petition for amendment. This approval does not relieve Highbridge of the need to comply with the terms, conditions, limitations, or modifications of the construction and operation of the facility authorized in the certificate. That concludes my presentation, and we're available for any questions you might have. Thank you.
Thank you, Ms. Chaudhry. I have no comments or questions on this item. Let me now turn to my fellow board members for any comments or questions. Mr. Alexander?
I have no comments or questions. Thank you.
Dr. Lewis Michael?
No comments or questions.
Mr. Ravishir?
No comments or questions.
Mr. Williams?
No comments or questions.
I will now call for a vote. My own vote is in favor of the recommendation as described. Mr. Alexander, how do you vote?
I vote in favor.
Dr. Lewis Michael?
In favor.
Mr. Ravishir?
I vote in favor.
Mr. Williams?
In favor.
The order is approved and the recommendation is adopted. Secretary Phillips, is there anything further to come before us today?
There is nothing further today.
Thank you. We are adjourned.